So, friends, I am so thrilled to have with us today on our Justice Matters YouTube channel, Ron Fein. He is the legal director of Free Speech for People, a remarkable organization that has been in this democracy battle for years. Ron, thank you for joining us today.
Thank you. It's a pleasure to join you.
And can you start by telling the folks who may not have heard of your organization, Free Speech for People, a little bit about the organization, what you do generally, and then very quickly, I want to move into some of the cases that you're involved in right now.
Yeah, Free Speech for People is a national, nonpartisan, nonprofit, public interest organization that is dedicated to fighting for our constitutional democracy. We were founded in January 2010 on the day that the US Supreme Court issued its Citizens United decision, which unleashed unlimited corporate political spending into our elections. And since then, we have continued to work on fighting big money in politics, fighting for voting rights, against voter intimidation, and more recently, for implementing Section 3 of the 14th Amendment, which demands that insurrectionists be kept out of public office.
And tell us a little bit about some of the disqualification battles you all have fought. Obviously, I'm interested in the Marjorie Taylor Greene battle. I know you started down the road challenging Madison Cawthorn's eligibility to continue to hold office. That one sort of mooted itself out. And I know you're involved in several others. So can you just tell us a little bit about your past work against the folks like MTG and then what you're doing presently?
Yeah, so right after January 6th, 2021, a number of people around the country, remembered Section 3 of the 14th Amendment, but most of them, if not all of them, were focused on what Congress could do. And so all the discussion from all the pundits was about Congress needs to pass a law, Congress needs to form a committee, Congress needs to pass a resolution, Congress. And what we at Free Speech for People realized is that states have a role in implementing the US Constitution. And in particular, many states have candidacy challenge statutes where ordinary voters can challenge the eligibility of a candidate for office under the constitutional qualifications for that office. So shortly after the start of the year 2022 in early January, we filed a series of challenges under Section 3 of the 14th Amendment against members of Congress who were running for re-election who had been involved to varying degrees in the events of January 6th. And these were the first legal challenges under Section 3 of the 14th Amendment in 150 years since Reconstruction. And we filed in North Carolina against Madison Cawthorn, in Georgia against Marjorie Taylor Greene, and in Arizona against Paul Gosar, Andy Biggs, and Mark Fincham. And they all played out in different ways. What's important to note is that although none of them actually resulted in a removal of those candidates from the ballot, they actually set important legal precedent that has been used in this year's challenges to Donald Trump.
Talk to me a little bit about what we saw with respect to the challenge of Marjorie Taylor Greene, because what I will say, Ron, what I saw just was stomach churning. I think at one point she may have forgotten what her middle name is. Okay, I'm exaggerating, but I have always tried to impress upon people that I don't know and I don't recall are not perjury-proof answers. If they were, I don't know that I ever would have successfully prosecuted anyone if I had to, except I don't know and I don't recall on information that was of consequence to my investigation or prosecution. So can you give us kind of the Reader's Digest version of how the MTG challenge that you all brought played out?
Yeah, so this was the first case that had gone to trial under Section 3 of the 14th Amendment, again, since the early 1870s. And Marjorie Taylor Greene, we forced her onto the stand under oath to answer questions about her involvement in January 6th. She was the first member of Congress, and I believe to this day, still the only member of Congress who was forced to answer questions under oath about their involvement in January 6th. And Georgia courts allow cameras at times, so much of the nation saw this. She claimed not to have recollection of videos of herself. So we would, play her a video of herself saying something or show her a tweet that she had made. and she would not remember it. She would not remember, posing with, white supremacists who were connected to people that later, were involved in the attack. She had no memory of any of that. The trial was held on a Friday, and in one case, there was something that she had denied any memory of. Over the weekend, a tranche of text messages were released that supplied the answer to what she had forgotten about supposedly on Friday, and we gave that to the court on Monday afterwards. In the end, the judge found there was a mixed decision for us. The judge issued some legal findings that were actually incredibly valuable. He concluded, and this is consistent with the history of Section 3 of the 14th Amendment, that you don't need to have been personally involved in violence to be disqualified under Section 3. And if you think about it, Jefferson Davis, the president of the Confederacy, never fired a shot on the battlefield. You don't need to have been convicted of a crime or even charged with a crime under Section 3. And that something like marching orders or instructions to capture an objective or disrupt or obstruct a particular government proceeding would constitute engaging in insurrection. Having said all that, he did say that we had not supplied sufficient evidence that Marjorie Taylor Greene, who, remember, had only sworn the oath of office on January 3rd, so he didn't consider most of her conduct before then, that she personally had engaged in insurrection. So she remained on the ballot, but what we got out of it was important legal precedent that has been cited and used in the challenges to Trump this year.
And when you say things like you need not fire a shot, be at the Capitol, be personally involved in trying to breach the Capitol or assaulting police officers or trying to stop the certification of president's election win, I can't help but be reminded of somebody who said, if you don't fight like hell, you won't have a country anymore. We will all march to the Capitol now. Go stop the certification, which from this old prosecutor's perspective was always such a wonderful evidentiary gift, because when he said stop the steal instead of the certification, he's actually proving his own corrupt intent, his criminal state of mind, his guilty mens rea. But I digress in my zeal to see insurrectionists held accountable. Can you tell us, Ron, now that you had that important experience litigating perhaps the only case trying to disqualify a member of Congress for participating, engaging in insurrection, how does that inform where your organization and where you are today on some of the disqualification challenges that you're currently pursuing?
So we filed a number of challenges in multiple states, Minnesota, Michigan, Illinois, Massachusetts, and Oregon, to Trump's eligibility for office. And these are filed at different times because different states have their own timetables and their own processes and procedures for considering candidacy challenges. And of course, as you know, CREW, which is a separate organization, filed a challenge in Colorado. In formulating these challenges, we relied heavily on the experience and the legal precedent that we had set in the Greene case, and also actually in the Madison Cawthorn case, which, although we never got to actually have a trial with him because he ended up losing his primary while that challenge was pending, it actually set other legal precedent we can talk about on some other technical issues. And so in formulating it, the evidence against Donald Trump is actually much stronger than the evidence was against Marjorie Taylor Greene. She was a secondary figure. He was the center of everything. He is the one who summoned the hostile crowd to DC on January 6th, the day that electoral votes would be certified, and said it would be wild. He's the one who gave that inciting speech, telling them to go down to the Capitol to block what was scheduled to happen in Congress that day. And he's the one who goaded them on as it was happening and refused to intervene in any way to try to stop it. So the factual case against Donald Trump is so rock solid that it's important to note that no challenge against him has ever lost on the merits. No court, no election official, no one who's actually reached the merits has ever said that Donald Trump didn't engage in insurrection. To the contrary, everyone that's ever decided the merits has agreed that he engaged in insurrection and is disqualified under Section 3. Those courts that have not disqualified him have relied on state law technicalities.
I want to throw in one additional fact, which I don't think we hear enough about, but we learned about it from the January 6th House Select Committee, when Donald Trump was advised by law enforcement that members of the crowd he was whipping up into an angry frenzy on the ellipse, I call it his pre-insurrection pep rally on January 6th, he was informed that members of the crowd were armed with firearms, to which you would think any person who was interested in the security of himself or of the crowd would say, we need to address this. No, he said, I don't care. They're not here to hurt me. Take down, his term was the effing mags, the metal detectors, let them in, and then we can all march to the Capitol. So he was facilitating an armed attack on the Capitol, or what I would call an armed insurrection. So just to reinforce your factual overview, the evidence that Donald Trump engaged in insurrection, again, from the perspective of somebody who was required to assess the strength and quality of evidence for my entire career, it's just overwhelming. It's breathtaking. So now, where do you stand on other challenges that you all have filed?
We have two that are pending, one in Illinois, one in Massachusetts. The Illinois one is at a better stage right now. We filed it before a hearing officer of the Illinois State Board of Elections. And he said, on the one hand, he didn't think that the Illinois State Board of Elections had jurisdiction to consider the case under Illinois law. But he said, if it does, this guy engaged in insurrection and should be disqualified, and had a detailed analysis of the factual record explaining why Trump engaged in insurrection, and Section 3 disqualifies him. That went up to the Illinois Board of Elections, which relied on the state law technicalities, and now we are in Illinois court challenging it. And of course, this is all happening under the shadow of the U.S. Supreme Court proceedings, and we'll see how far we can get in the meantime.
I actually have gone so far as to say, this is my take, that there's really no legitimate reason for them to accept this for review. Now, we all know sometimes they want to be the big dogs and they want to issue an opinion, but they really ought not accept review just to issue an opinion that says, we agree and we want our voices and our rationale heard on that. Of course, this is a real outlier, but you want to do that, fine. Don't grant the stay and then accept it for review and write whatever you want to write. I don't expect it will go that way. So let me ask you as a wrap up, where can people find you? How can people support the remarkable work that you and John Bonifaz, and I'm sure the many others who populate Free Speech for People are doing, because you all are kind of free agent justice warriors and democracy fighters, the way I think many people have become in an age when the government pretty clearly either cannot or has declined to address all of these issues to kind of keep our democracy healthy and viable and moving forward. And, you know, people like Crew and Mark Elias and Free Speech for People are jumping into the breach and really trying to keep our democracy up and running. So how can people find you? How can people support the great work you do?
Thanks for the question. So we're on the web at www.freespeechforpeople.org. And as you said, we have been at the forefront. We were the first national organization to call for Trump's impeachment when his only impeachable offense was emoluments. And then we led the impeachment movement for the duration of his presidency. And as we've discussed, we were the first to use Section 3 of the 14th Amendment. To the extent that we face crises and threats to our constitutional democracy under Trump or any other presidency, we are at the forefront of fighting for our constitutional democracy at freespeechforpeople.org.
One final question, then I'm going to let you go. I've been intrigued, and I've heard a number of times that your organization was born immediately after Citizens United, which is a decision that I think so many of us feel has worked to the detriment of our nation and our democracy ever since it was decided. How did it come about that Free Speech for People was founded the very day after Citizens United was decided by the Supreme Court?
So this is before I joined the organization, but after the oral arguments in Citizens United, John Bonifaz, our president and co-founder, and then our other co-founder came together, and they understood where the Supreme Court was going. Just like we're talking with the Trump case, you know, sometimes you can see that the fix is in. And so they knew what was going to happen. And so they prepared to launch the organization on the day that the Supreme Court issued its decision. And we were, again, the first organization to call for a constitutional amendment to overturn Citizens United and to restore our First Amendment to a system that protects the right to speak freely about politics, but recognizes that unlimited money in elections is not the same as speech.
Well, thank you again, Ron, for what you do, what your organization does, and thanks for taking some time to chat with us here on Justice Matters today.
Thank you. It's been a pleasure.
Justice matters.